We'll edit it moving forward. Okay, guys, let's go ahead and get started. I would like to welcome everyone to the Marijuana in the Workplace webinar. This is a program of the Surprise Regional Chamber of Commerce. I would like to recommend everybody use the Q&A feature on the Zoom webinar feature if you have any questions. Today's program is being recorded live, and the program will be rebroadcast on our social media feeds, including Facebook and our YouTube channel, and we'll also send a link out to our list of all businesses. My name is Raul Sada. I'm the president and CEO for the Surprise Regional Chamber of Commerce. We have a wonderful lineup of guest speakers today on a topic that there has been quite a bit of interest in. In order to speed up the process for today, I'm going to go ahead and pre-introduce our lineup of speakers. First, we're going to have Brandon Klippel, who will make some opening comments on behalf of the Chamber. Brandon owns Vista Sima Wealth Management and is the incoming chair of the board for the Chamber of Commerce. Today's fireside chat moderator will be Chris Herring. Chris works for the University of Phoenix, and when he's not doing that, he serves as the government relations chairperson for our Chamber of Commerce. Our two special guests are both individuals that you've probably seen on local TV stations, Business Journal, and they're very often quoted in various publications. First is John Balitis with Jennings and Strouss. John counsels the private sector clients as well as government agencies, including Arizona legislature, on a broad range of employment law and labor relations matters. He has over 30 years experience in practice and has represented clients in administrative proceedings before the EEOC, the U.S. Department of Labor, National Labor Relations Board, Arizona Civil Rights Division, Arizona Industrial Commission, Arizona Department of Occupational Safety and Health, and the Arizona Department of Economic Security. John is also regularly cited in a lot of business journals and media, and also has participated in drafting and testifying on Arizona employment-related legislation. Our second distinguished panelist is Joshua Black. He is with the law offices of Joshua Black. Joshua regularly represents his clients in both state and federal court and appears in agency proceedings before the U.S. Department of Labor, the Equal Employment Opportunity Commission, Arizona Attorney General, Civil Rights Division, the Federal Merit Systems Protection Board, and the National Labor Relations Board. Joshua also makes a lot of celebrity appearances on Fox 10, Channel 3, CBS 5, NBC, and various other local radio stations. So with that, I'd like to go ahead and turn this over to Brandon for a few opening comments on behalf of the Chamber.
Great, thank you, Raul. That's a very impressive resume for both of our guests, and we're looking forward to hearing from them. We'd first like to just thank everyone for being on the call today. We're grateful that you're here, or if you're listening to this recorded, we know that this is something special. At the Chamber of Commerce, we look for ways to be conveners and helping people to coordinate and find information that's relevant to their business. I've owned a business for a long time here in Surprise and looked at opportunities for me to have a voice. And what really impresses me about the Chamber is this idea of advocacy, knowing that I have an advocate for my business and what I'm trying to accomplish. So this helps us to achieve that goal. We know that there's a lot of things going on in the community and in our state and even in our government that will affect our businesses. And when we work together as a chamber, we can help the businesses to have that voice. And I think Chris is a great person to help us lead this discussion. Chris is a great colleague and friend, and he's a member of the board that represents it in every great aspect of the board that, or the chamber that you can have. So we'll be glad to have him moderate this for us. But I want you to be able to just take a few things away from this and find value in it. there's great value in what the chamber has to offer in you as a business owner or as a leader in the community. And as you see that value, that you use that then to be able to help the chamber propel forth in that message that we want to share, that we believe that we are champions for the business community, and that we can help you to have that as well in your business and be a champion with us. So without further comment, I'm going to turn it now over to Chris and let him take it from here.
Awesome. Thank you, Brandon. Well, we're going to jump right into things today because this is a hot topic and something that I know our members are very interested in and have a lot of questions, a lot of important questions. And so we're hopeful that we are able to cover much of that today with John and Joshua. So John and Joshua, the way we'll do this is kind of open forum. So I'll kind of let you battle it out a little bit for who responds to each question. I'm not going to over moderate it because I want it to be kind of a comfortable back and forth, kind of free flowing dialogue here. And I'm going to open it up with just a couple remarks, and then we'll get into a basic question. So for all of our members, Prop 207 passed, and it means that for the state of Arizona, as far as state law is concerned, marijuana simply being carrying up to an ounce or testing positive for having consumed marijuana is no longer directly in violation of state law. But there are a lot of complexities in terms of when you can consume, how recently, how much you can have, what's that mean for your job, especially what we're talking about today. And then what does it mean for state? What does it mean for federal and interstate commerce and things of that nature? So we'll be getting into those issues today and hopefully getting some great clarification. So John and Joshua, first question in general is, now that Prop 207 is passed, what things should employers be concerned about first? What are the first actions that an employer should take now that this new law or new set of rules is in effect?
Well, I'll start. I think really, Chris, what employers need to do now is just be more vigilant because, this Prop 207 has already become effective. So although people are not going to be able to purchase marijuana retail until probably March or April of next year, once Governor Ducey certified our election results, the use and growing provisions in the proposition immediately became active. So as of today, each one of us has the right to grow up to 6 plants in our household for non-commercial purposes. If you have 2 or more adults residing in the household, you can have 12 plants growing. You can use it. You can possess up to an ounce, like you said. You can transport it. There are places, obviously, that are restricted from use, like public places, bars, restaurants, things like that. But it's already effectively been decriminalized. And the reason I bring all that up is because what that means for businesses is they likely will just see a larger census of people potentially coming to work under the influence of it. Because there's no reason for anybody who wants to use it not to use it anymore. It's lawful, right? But what we need to keep in mind is that Prop 207 makes absolutely clear that employers in Arizona are not impacted at all in terms of how they can manage individuals who use marijuana recreationally. The proposition says right in it that employers have the right to continue to maintain a drug-free workplace. So Prop 207, other than the increase in use that probably will be reflected in the workforces, really isn't going to impact too much the day-to-day personnel decisions of employers. What we might want to talk about a little bit later is what's happening to the safety-sensitive job prohibition on medical marijuana use that came with Prop 203 back in after 2010. That is what's really what's coming to the forefront right now in terms of marijuana law as it impacts employers. But I don't really see Prop 207 as a huge game changer for businesses, really. But Joshua, probably will want to tack on to that.
Yeah, Joshua, what are your thoughts?
Thanks, John. I think that those are really good points. And I agree that for the most part, Prop 207 really shouldn't have any impact on the daily working environment. As long as you have a handbook and you have appropriate policies in place about recreational drug use, you shouldn't really have a problem. There's not any real new rights under Prop 207 to be impaired at work. And that's, I think, the biggest misunderstanding. Like John was saying, public places, you can't be out, smoking weed at a restaurant. You can't be driving impaired. That's always been illegal. You can't be impaired at work if your company has a policy against such things. And that's the same as if someone is taking, Oxy for their back, right? If somebody's on some sort of serious painkillers, you likely already have policies in place. If you have a robust handbook that says employees aren't supposed to be working or coming to the work premises while they're impaired, I think that those policies should be looked at. And that's probably my biggest takeaway for everyone who's going to watch today is, if you're a business owner, take a look at your handbook and just make sure that you're in compliance, not only with recreational marijuana, but it's a good time to look back and make sure that you are in compliance with the Medical Marijuana Act as well, that was passed several years ago, because I do still see a lot of employers who haven't addressed that at all in their handbook. And that's something that personally I believe should be addressed, because you want to differentiate. If you have a zero tolerance for cannabis use, you need to make sure that there's an explanation there that you are not talking about medical marijuana use, because employees do have rights to use that, which of course we can discuss in more detail.
All right. Well, I think that's a great answer for a lot of our employers who will be watching this and saying, what do I need to do? And I think that's the main question that we've been getting is what do I need to do right now? They're worried about how are they covered, how, what policies that they change. And it sounds like what we're hearing is, recreational marijuana is similar to recreational alcohol consumption or any other substance that may alter an employee's performance. You're allowed to watch for it, and you're allowed to have policies that are stated clearly for an employee that say, hey, you still have to be able to perform your work in a manner that's acceptable. So that is, I think that's a great answer for our employers that are listening. Let's talk a little bit about types of work that employers need to be careful of in terms of both employee safety and liability. What types of work, we talk about obviously driving, right? Operating machinery, driving. What other kind of work would not be, or should employers be careful of, I guess, in terms of having special policies and continuing drug testing programs, things of that nature?
Well, Joshua touched on the fact that, employers need to have robust policies to differentiate between what the employer is going to prohibit when it comes to just a recreational user versus a medical marijuana user. And this relates a little bit to the comments I made at the very beginning. When we passed, as voters, when we passed Prop 203 in 2010 and legalized marijuana for medicinal purposes, that referendum did provide to workers a lot of rights that some of the other referenda around the country, 20 or 30 of them or so, didn't afford to workers. It was kind of like a sort of a new version of this type of law. And Prop 203 essentially said that an employer couldn't do anything with a medical marijuana card holder, couldn't discriminate against them, couldn't lay them off, couldn't refuse to hire them, unless the employer had subjective evidence of impairment in the workplace. You'd have to actually see something. And that startled the business community and frankly, the chambers around, because for employers with safety sensitive workplaces, heavy construction, machinery, equipment, even people driving vehicles, it almost forced employers into a situation where they'd have to wait potentially for an accident, someone to get maimed or hurt or killed before they could take any action. And so the legislature a few years later amended our drug testing statute to deal with this issue. And now, if you have a policy that says so, you can regulate a worker who is in a safety sensitive job if, as a business, you develop a reasonable belief that the employee is working, using a drug that could cause impairment, whether it's marijuana or some other drug. And so you, as employers, once that subsequent legislation passed, businesses in Arizona gained a lot of flexibility then to deal with workers that the original referendum didn't allow. The problem that we're seeing now is, and this just happened last month, or I should say in October, is workers are finally coming around to challenge that change that the legislature made to our drug testing statute as unconstitutional. Because, you know, Chris, as you probably know, the Voter Protection Act really restricts the legislature from amending a voter-passed referendum. And that's what this legislation did. It kind of was an end run around the referendum. It did it through amending a legislatively passed piece of law. And now claimants are challenging it, claiming that it's unconstitutional under the Voter Protection Act. So employers should keep an eye on this, because we are coming close to the potential for a court, a federal or a state court in Arizona, to declare that those amendments to the drug testing statute, which gave businesses flexibility to manage medical marijuana users, are going to go away. And if that happens, then the whole game will change for employers in Arizona, because it's like almost everybody will be a recreational user again, whether you're, or a medical user, because there won't be any way to really regulate the worker other than subjective evidence of impairment.
Yeah, and you bring up a good point. Oh, go ahead, Josh.
Sorry, Chris. I think that is a good point. And something that we usually recommend to our clients is to have some sort of impairment checklist that you train managers on and that you can look at, because you want to be able to have specific data to say, this is what I experienced. You know, it's not going to be enough to say, oh, I think that person seemed high. Well, what does high mean? You know, you're going to have a much higher burden as an employer than that. If you have some sort of checklist that you go through, okay, did they have watery eyes, red eyes? Were they slurring their speech? Were they moving slower than normal? Did they have a certain odor? You know, if you have these types of things that you can identify, and it's great if you have more than one manager as well, or more than one employee who can fill out one of these checklists. I think that's going to go a long way towards addressing impairment, whether it's under the Medical Marijuana Act or under Prop 207. That's probably going to be your best tool right now to have documentation to show, hey, this really was an impairment at work situation.
So, and I want to get back to that. I just want to give our members an aside, because something John said, regarding the initiative process. And, this past cycle, we were public about saying that the Chamber of Commerce in general is not in favor of the initiative process. And the point John just made was specifically why, regardless of what the initiative is, in Arizona, when an initiative passes, it becomes extremely difficult to improve it. And improve it's usually what needs to happen, because it hasn't gone through a typical lawmaking process. And in the typical lawmaking process, there's a ton of back and forth that takes place over months and often years before it becomes law. And that works out a lot of the kinks. And since we have two attorneys on the phone, they can tell you when you don't do that, it's almost always going to end up in court. And then usually nobody's happy, because it's up to a judge, or sometimes several judges as it gets appealed, to make a decision. And oftentimes that strikes down portions of a law that may have been good or may have been necessary for the entire body of policy to work. And so we oppose the initiative process in general, because we've just found that it's not an effective way to create good policy. And so, we always advocate to send things through the state legislature and let that process take place, because we end up with much better law and much better government that way. So I'm going to use that as my soapbox for this chat. So I want to get back to, kind of what's changing in terms of enforcement and testing. So Joshua, you brought up, things that you can do that can lead to enforcement, right? You mentioned having several people be able to account for behavior or evidence of impairment, physical signs, things of that nature. But let's talk about testing. One of the things that came up the last few years when this has been on the ballot, because it's been on the ballot more than once, is the idea of how do you enforce it? How do you prove that somebody was indeed under the influence of marijuana and therefore impaired? And different than other controlled substances, marijuana can stay in your system or can have signs in certain tests for a long time when there are no physical changes. So you're not actually under the influence any longer. It may not have been for a while, but you can still test of having consumed. So how should employers address that? If they have, say, a policy where you can't be under the influence at work, which I would say most employers do, at least for impairment, how do they go about testing? If they say, they come to an employer and they say, no, it's clear you're impaired, and they test, how do they prove it? What's the burden?
Well, I think that that's a good question. And I think that the test itself, as it works right now, is not a real conclusive piece of evidence. It's something that can bolster the reasonable suspicion checklist and the testimony of the other employees. If you have a suspicion that employees under the influence, fill out your documentation and then send them to get a drug test. The concern, though, is going to be that the data that you get in that drug test may or may not be particularly useful. I mean, if it came back and it showed no marijuana particulates, there was no THC in their urine, then I guess that could prove that they weren't under the influence and they were just acting strange. But presumably it would go the other way. And if they're a recreational user or they're a medical user, depending on how often they use, your analysis can show the metabolites for anywhere from a week up to a month later. And there's no way currently, from my understanding of the test, to really connect the dots to say, okay, this level of metabolites in the urine is equivalent to this level of impairment. It's not like we can do with alcohol where we can do exactly that and say, okay, this level indicates this impairment 30 minutes ago, 1 hour ago. Marijuana is just not there as far as the testing. And so, John, I'll let you chime in on that too. But my thought is that would just be another piece of evidence that's kind of bolster your overall argument.
Yeah, well, I kind of have two observations about this. One is that we need to keep in mind that now under Prop 207 and also for safety sensitive workers after Prop 203, if an employee tests positive, even just for metabolites, even if there's just a trace of THC in that employee system, you can discipline them. You don't have to prove that they were impaired by marijuana. So that's important to keep in mind, although the caveat is, as I've said twice now, all the businesses need to keep an eye on this issue with the safety sensitive job exception to the medical marijuana referendum. It's extremely important and it's creeping up on us. But
John, real quick. So with that, does an employer need to have a drug-free workplace policy in place in order to discipline in that manner?
Well, when our legislature passed our drug testing statute in the mid-90s, it did it because it wanted to provide a universal and what the legislature thought was reasonable and fair template for a drug testing policy. And what the legislature did when it passed that law back in the mid-90s is it said, look, here is a template for you businesses to use to implement what we think is a reasonable and fair drug testing policy. You don't have to use it. And there's no penalty if you don't use it. But if you do use it and you satisfy every criteria in the template, you get certain protections. If you fire somebody for failing a drug test, they can't collect unemployment compensation. If you fire somebody for failing a drug test and you fire them they can't sue you for defamation or whatever. This latest safety-sensitive job flexibility was one more protection that the legislature added as an afterthought after the medical marijuana referendum. So yes, in order to do these things, you do have to have a policy as an employer that is fully compliant with the Arizona drug testing statute. If your policy is not compliant in every respect with the criteria in the template that's in the law, then you don't gain these protections. So that's a really good important point. But to Josh's point about, I totally agree with the proposition that we haven't been successful yet, maybe we never will be, in assessing impairment with THC as we do with alcohol. But back when the legislature was entertaining a way to try to fix that dangerous proposition in the medical marijuana referendum, one thing that it considered, and I went down and I talked at some stakeholders meetings, was why don't you as the legislature establish an objective standard for marijuana impairment? Let's put it in the law. And there are white papers that are floating out there in the ether that people have authored that actually attempt to connect a certain THC level with an objective evaluation of impairment. And some states, like Pennsylvania, for example, have adopted an objective level for law enforcement purposes. So in Pennsylvania, for example, if you get pulled over and you test above a specific threshold, like blood alcohol content here, for example, then it's strict liability. You're guilty unless there was a problem with the calibration of the testing equipment. And the suggestion I made was, why don't you guys just adopt one of those objective standards that a legislature somewhere else around the country has adopted to regulate this? And oddly enough, law enforcement was completely opposed to it. And it never went anywhere. And as a consequence, the alternative they decided to adopt was the safety-sensitive job exception that we've been discussing. So it's kind of it's interesting. There isn't a lot of support for this idea, like Josh said, but if you snoop around, you can find places that have tried it and have implemented these objective levels. They're not particularly scientific, though. There's a lot of subjectivity that went into those determinations.
Josh, it sounded like you had something there.
Yeah, I wanted to bring up, talking about these safety sensitive positions. It's something we haven't mentioned yet, but that's another area of needed documentation. I think you'd probably agree, John, that if you have positions that you believe are safety sensitive, if you're employing drivers, machine workers, people that you feel are in those positions, you have to label it as such. You want to make sure you put those keywords in the job description, because that's going to, at least for now, be your protection when they do test positive and you want to let that person go. You've got to be able to go back and show that you considered this job safety sensitive, because there is a list, but there is not an all exhaustive list. And so you can't just say, well, it seems safety sensitive to me, so I'm going to go with that. It should be written down somewhere.
I think that's a good point for our employers out there to maybe go back and review that and get some counsel if they're not sure. And I won't be surprised if that list changes, since we are talking about, kind of bleeding edge policy here, right? Which you both hit on, the fact that a lot of these policies untested, even though we have, 30% of states, something close to that now, that have some form of recreational usage allowed, it's still fairly untested. And so, getting some counsel and reviewing the policies is definitely something we're going to keep encouraging our members to be doing. And so it sounds like that area of strictly defining, or maybe in their case, broadly defining, but specifically defining what is needing to be safety protected. Let's talk a little bit about the uncertainty legally. So, historically, since this has happened, Oregon, Colorado, some of the biggest ambiguity has been around the conflict between states, and so multi-state employers, and then also with federal regulation, where marijuana is still a federally controlled substance. Is there anything, now that Arizona is in the group of states that has legalized recreationally, that employers should be considering with any federal liability?
Joshua, do you want to start? I can start.
Yeah, I would start by saying that there's another sort of protection for employers if you have federal contracts already under the Arizona Medical Marijuana Act. And so if you're an employer that receives federal funds or relies on federal grants or contracts, you'd likely be in violation of those agreements by allowing employees to use a federally controlled substance. So if your company does work with a federal agency, you can say that you don't permit the marijuana use even for medical patients. And I think that would be kind of the biggest protection out there.
Yeah, Joshua is right. There is one complete get out of jail free card embedded in Prop 203, the medical marijuana proposition. And that is, if you're an employer that does perform work for the federal government, and if you didn't have a completely 100% drug-free workplace, it would put your relationship with the federal government or your funding at risk. That simply undoes all your obligations under the medical marijuana referendum altogether. You can have a completely 100% drug-free workplace and not have to worry about any of the protections or bells and whistles in the referendum to protect cardholders. One thing I will note, though, is you may have been aware of this, but just last week, or it might have been Monday, the House, this is a federal bill that passed in Congress, passed its own version of a law that would deschedule marijuana at the federal level. And it was supported by, among others, Kamala Harris. It was a bill that was supported heavily by the Democratic majority in the House. The conventional thinking is that when it gets to the Senate, it's going to die because depending on what happens with the runoff in Georgia, we may still have a Republican-controlled Senate where it's going to probably fail because it's a bill that Democrats are supporting, but not so much Republicans. The message here, though, is that there is momentum that is being gained at all levels. Chris, you talked about how many states now have done this. Now Congress is entertaining it at one level or another. It's not going to be long, at least in my view, that marijuana is decriminalized entirely. And the bill that the House passed would then also expunge pretty much all medical marijuana offenses for people who had been convicted of them. So it's a very sweeping, they're considering very sweeping legislation at the federal level. I don't think we have to worry much anymore in light of that. You may remember Eric Holder way back when we passed our law for medical back in 2010. He was writing letters to, the attorneys general and states saying, we're not going to mess with your patients, but we reserve the right to come in and arrest people who are growing and distributing and stuff like that. It never happened. It never happened. So I think that I don't really think there's any concern anymore about the federal government doing something to try to reverse or challenge what all the states are doing. It's going in the exact opposite direction. We're just going to see more and more of this at the state level, and then probably pretty soon at the federal level.
Yeah, I agree with that, and we've talked about that as a chamber last year. That's kind of a modern trend in federal policymaking has been let states do it, and once it reaches critical mass, it goes federal. So I agree. I think we'll see it sooner rather than later, which will probably be a good thing in terms of policy goes. Yeah. Wherever you land on marijuana, personally, in terms of policy, it's usually good once we can nationally have an agreement on something that does affect every state. So hopefully we'll learn more clarification and more guidance. And I know for our employers, that is a key thing. When you're thinking about liability, you just want things to be clear so you know the right actions to take. So hopefully we do get some clarity at the national level in the next few years. Let's stay on this topic of kind of contract. We talk about interstate commerce. Arizona up until November 30th was a state that had marijuana as an illegal substance. Now you can use it for recreational purposes. Now you can use it recreationally. If there are employers that had contract agreements to guarantee they operated a drug-free workplace, it sounds like there shouldn't be any problem. They should be able to maintain those policies and uphold those contracts. So is there any contract law, other than we talk about federal contracts, but any private business-to-business contract law issues that either of you see changing now that marijuana recreationally is allowable?
Business to business? No, I will say that one thing these are probably employers in the minority in the state of Arizona, other than mines and some large operations that traditionally have been unionized. But if in the wake of 207, an employer is thinking about creating a drug-free workplace because they're worried, as we said at the very beginning, about a higher number of people potentially using and maybe coming to work impaired, so they want to beef up their drug testing policy, unionized employers need to realize that they may have a duty to bargain before they can do that. You know what I'm saying? So it gets to your point when you say contracts, because collective bargaining agreements are forms of contracts between employers and workers. There's just a union in between that acts as the liaison for making that contract universal among all of the workers. And unionized employers can't lose sight of the fact that they just can't run around like doing whatever they want all the time, because in most cases they'll have to bargain either for a particular right or to impasse on it before they can just implement it. And that would be a contract issue just for union employers, it's not a business to business issue.
Yeah, and I think that John kind of hit it on the head. That's the only big thing I can really think of. I mean, business to business within the marijuana business itself, there's likely to be changes. The industry has a lot of trouble contracting with banks and using banks. So as we're talking about how this is changing in different states and likely federally over the next 4 years, there'll be a big difference in how those marijuana businesses can operate and get funding. I guess I would also say, for any of our watchers or listeners who want to get into the marijuana business, I guess if there's anybody on that side of the curiosity, there's still a lot of hurdles to go through. Prop 207 definitely doesn't open the floodgates for you and me and our neighbor to go and set up, marijuana dispensaries in our garages. It's not like that. There's a lot of licensing to go through and specific requirements that are needing to be met. So if there's anyone interested in that, I would just say, you can look at the text of Prop 207. That's a little off topic for our general discussion, but you'll find a lot of good information in the proposition about what your requirements would be if you're interested in being involved in the business.
Yeah, interesting enough, when Prop 203 passed, the licenses for medical marijuana facilities, now this was 10 years ago now, but they were going for about $300,000 if you could get one. And the latest I've heard is the recreational licenses that have gone up for auction, because keep in mind that the medical marijuana dispensaries are going to be the first platforms to sell recreational. So if a medical marijuana dispensary that exists now wanted to try and market its license, its recreational license, the going price for the last two that sold at auction were $12.5 million a piece for each license. So,
Wow.
Back in the day, 10 years ago, people were still, and to Joshua's point, one of the big concerns was just the simple logistical problems. I have clients in this area, and for a while they would just have to take huge bags of cash to banks. It was just a dangerous proposition because they couldn't have a banking relationship. And I think back in the day, it was kind of like, I don't know if this is going to go anywhere. It seems really sketch. But nobody's got a crystal ball. So $300,000 for a license back in 2010, $12 million for a license now. So I guess if that tells anything to employers, it probably should tell you a little bit of something about the quality. Like Joshua said, these aren't going to be fly by night. You know, I think California, for example, is an entirely different proposition. They like popped up all over the place, like vape shops. Here, I think, what is there going to be 130 licenses for the entire state, Joshua, something like that?
I thought it was 170, but I could be off, but it's in that range. It's less than 200. Yeah.
Yeah. And that's including rural areas and everything. So these aren't going to be all, and Prop 207, interestingly enough, gives local governments the right to ban dispensaries if they want to. A local government doesn't have to zone and allow a dispensary to open. It can, under the proposition, it can say no. And then the dispensary would have to move to the next location that would allow it for zoning purposes. So there's a lot of regulations that are designed into the referendum to safeguard us and employers as well. I guess that's the message.
Yeah, and for anyone who's listening, for the Surprise Regional Chamber, that is something that's come up. The City of Surprise Council has been publicly split on the issue of zoning for dispensaries. So I think that's something we'll see kind of explored. You know, I don't want to, how else do I say, it's going to be fought out in different municipalities for sure. And I think marijuana, it's like any other vice business. Where do you place your vice businesses? Do you want them in your city at all or not? And marijuana will be the next round of political battles around that we'll watch. And I think employers look at that as well, because if I own, manufacturing, or if I own distribution centers, do I necessarily want a marijuana dispensary nearby? Because it's going to affect the employees that I have and the likelihood that I end up with issues. And so, we definitely are going to keep, as a chamber, making sure that the public is aware that there is a trickle down effect. Maybe it's not even trickle down, it's often immediate, that when you put these things into communities, there's questions you have to account for. And so I don't think anybody goes about it lightly, but we do want them to know, Surprise is a bedroom community that has a lot of light manufacturing and warehousing and distribution. So if we end up with a recreational marijuana problem, that could definitely affect the likelihood of employers wanting to locate here. And that is a new thing for cities and towns to discuss. So we've got about 15 minutes left. Are there topics that you all thought we would go over that we haven't covered yet? The biggest ones, honestly, for myself coming in, that I want to make sure our members were aware of, were the human resource and the liability pieces that I think you both covered beautifully. And so those are the ones that we wanted to make sure we got some great clarity on. But were there topics that you were hoping we discussed that you wanted to bring up, Joshua or John?
I think we hit on all of the big topics. Obviously, there's so many unique situations that can come up, and each company can be a little bit different in what they need or what they're looking for. So I would certainly say, it's worth the money to reach out to someone like John or myself. If you don't have counsel, you haven't had someone recently go over your documents, your employee handbooks, or if you don't have a drug policy, reach out to someone. We're happy to help employers. That's what I do. I know that's what John does as well. Our job as employment attorneys is to help your business thrive, to make sure that you're not too busy dealing with employee issues and liability to go out and make money and run your business, and having these things in place before you have a problem is really key. You don't want to wait until you have someone crash a forklift and they seem like they're under the influence, and then think, okay, maybe we should have a policy that says you can't drink or you can't use drugs at work. I mean, these are things that a stitch in time really does save 9, to quote the old adage. So that would just be my big takeaway is, reach out to somebody and make sure that your policies are up to date, educate yourself on some of these changes. We've been talking about Prop 203, which was 10 years ago now, but a lot of employers still don't understand how to handle medical marijuana at work. And that doesn't go away. That's something we haven't mentioned. We've alluded to that, but Prop 207 doesn't replace medical marijuana. They're two completely separate, independent systems that are still going to run in our state. So we just have to make sure that we're addressing them appropriately as an employer so that we can keep our workplace safe, but also not expose ourselves to liability for potentially firing someone that could come back and sue us on a technicality.
So we had a question, and I didn't want to cut you off before you got started, John. We had a question that came in through the Q&A around master service agreements from clients to subcontractors. So we have a member who is a contractor for a national client. And so the national client, their master service agreement requires all contractors to be zero tolerance, drug-free workplace. Does anything change with that? From the client perspective, can they still require that of all Arizona contractors? Is part one of the question. And part two is, does the contractor need to change any policies regarding 207? I feel like we've covered some of that, but do either of you want to cover it specifically?
Well, the point that Joshua made first earlier about federal contractors, if this client that has subcontractors here is federally funded, there wouldn't be any problem with having that provision or that requirement in that agreement, because if that federal money is trickling down from that client to the subcontractors here, those subcontractors, if they don't have a completely drug-free workplace, likely are going to not only put their contract on the line, but potentially they could put their client's federal contract at risk. So in that scenario, there wouldn't be anything wrong with that, having that requirement there. But
what if it's a private client, no federal dollars?
Okay, so there's no federal dollars, and unfortunately, if the subcontractor here fulfilled the requirement of the national client and said, we're going to have a completely 100% drug-free workplace because our national client is requiring that of us, that would run afoul of the Medical Marijuana Act, even as amended by the safety-sensitive job provisions in the drug testing statute, because once again, that employer can regulate safety-sensitive jobs if it develops a reasonable belief that a worker in one of those positions might be using a drug that could cause impairment. So they would not be taking advantage of that flexibility, for one thing. And then if you have a worker who is a card holder and is not in a safety-sensitive job, like let's say a call center person sitting in a cubicle, just answering the phone all day, doesn't use equipment, doesn't have to drive a vehicle. An employer in Arizona cannot say to that call center worker who holds a card, you have to be 100% marijuana free. Not lawful in Arizona. Not lawful in Arizona. The only employee that Arizona employer can say that to is a safety-sensitive job holder if they have a medical marijuana card. So there are nuances there that I think that whoever asked the question would want to explore, because having that provision in their, or that policy for their workforce at the behest of their national client could create issues. It's not that black and white. It's not that black and white.
So it sounds like they need to go back to council and have that MSA looked at.
Yeah.
And I'm going to guess, having dealt with similar issues, not drug related, but other issues in my day-to-day, that likely the client's the one that needs to review their MSA if they're going to continue doing business in Arizona or other similar states. So I'm sorry, I'm flipping back. So if you see me going into the camera here, it's because I'm going to the Q&A. So I'm reviewing to make sure we're covering these. We have one, and this is pretty specific. I haven't seen before. It says, can an employer prohibit company vehicles from visiting a dispensary? I'm not sure if that's been tested in Arizona or not. I'm not sure if there is legal precedence on this in Arizona, or if there's any policy written about it.
I don't know that there would be any precedent on such an issue yet, not that I've heard of, but my initial thought would be whether you're a medical patient or a recreational patient, you have no business visiting a dispensary while you're on duty. So the only time that could really happen, I guess, is if you were a person that takes home a vehicle. And I would then say that at that point, it would likely fall under the same policies as any other conduct outside of work. So in the same way that, you know, if you're an employee and you go online and you say, hey, I represent company A, you know, I'm employee of company A, and you start making political rants or racist rants or, you know, whatever charged statements that you make, we see people get fired for that all the time. You know, they're out there representing the company. If they're on their LinkedIn, for instance, and they're making these comments, I would look at it the same way. I would say that, you know, it's affecting the image of the company and goodwill. If you have vehicles, I would have a vehicle policy that makes it clear. I mean, it's got to be a lot of places that you probably don't want your vehicle sitting, strip clubs, you know, I mean, any, like you had said before, Chris, any vice establishment, if we want to call it that, I think you'd be within your rights as an employer to make sure your equipment is not branded out in front of one of those establishments. John?
Yeah, well, I mean, think about it. Just you could also think about it in terms of just reducing that scenario, like simplifying it to think about just company property in general. Like an employer can say, here's a laptop, but you can only use this for our business purposes. It's not a personal device. Maybe same thing with a company issued phone. And most employers, if they do have company vehicles, they will tell their workers if it's a scenario like Joshua described where the worker can take a vehicle home, they're not allowed to do personal errands or anything in that vehicle. The vehicle is for going back and forth from work, and then during the workday going out to presumably places that they need to go to for purposes of their job. If they want to go to a medical marijuana dispensary or a recreational dispensary, they take that car home, get in their personal vehicle and go. Because there's nothing wrong with an employer saying, just as a general proposition, here's your company vehicle, but you can only use it for company business. So I don't think there'd be an issue with that at all, right?
So it sounds like possibly revisiting some policies on the company vehicles as a blanket policy, and,
yeah,
and maybe not directly related to dispensaries of marijuana.
Mm-hmm.
All right. And there was one other question that did come through. I feel like we've answered this one. It was about advancements in testing that verifies employment. We covered that earlier. So I feel like that one was sufficiently covered, and all of us are eagerly anticipating better testing. But right now it's not really where we'd like it to be. So, well, I'm going to go ahead and start to wrap us. So we're about 5 minutes till. I didn't see any new questions come through in the last few minutes. So John, I didn't give you the chance for any final thoughts. We got into a little bit of Q&A after Josh had spoke. Anything that we didn't cover that you felt was important for our chamber members to know on this policy?
I would just say to sort of tack on to one point that Joshua made a couple of times, and that is if you are an employer and you either don't have a drug testing policy or you do, and you're wondering whether it's compliant with the statute so that you can gain the protections we've been discussing, that's a really good trigger for you to go to counsel and have that policy looked at. Because I'd say half the time when a new client comes to me and says, hey, here's my handbook and here's my drug testing policy, half of the drug testing policies I see are not compliant. And it's easy to make them compliant, but that employer it's not exploiting all of that protection that it can get, right? That if they just make it compliant with the template. And in addition to that, I will say that it's not only just about, so then let's say someone comes to Joshua or someone comes to me and we say it's not compliant. And they say, well, either can you make it compliant or give me a compliant policy? And then he and I do that. It doesn't actually stop there, because the statute has literally about 25 criteria in it. And some of the criteria involve things that the employer can and cannot do. So once you hand over that policy, there needs to be a little time spent with counsel where counsel says, okay, now I want to just focus on maybe 10 of the 25 provisions in this policy. You need to do this. So there's some training, there's an element of training in it so that they take advantage of the policy that you just now gave them. So there are good reasons to get some advice on this for all of those questions and issues.
Well, thank you both very much, and we'll kind of leave that as our closing thoughts. We get these questions a lot under new policies at the chamber. A lot of members say, "Can the chamber help me out with my HR policy or this legal question?" And so I think it's a great reminder. If you've attended something like this, or you're watching this on Facebook afterwards, and you're still saying, "Well, this isn't clear to me," our recommendation as your Chamber of Commerce is seek out counsel like Joshua and John. To get that official clarification, to make sure you're covered with your potentially new liabilities, or if there are changes you're going to make sure that you're buttoned up, because these are not necessarily black and white issues right now. There are still gray areas, and there's still new things that unfortunately we're all having to work through as these policies change state to state. So John, Joshua, thank you both very much. And I will go ahead and turn it over to Raul to end our session.
Thanks, Chris.
Well, I see there we go. Well, I just want to echo Chris's comments. Thank you guys for participating. And like I mentioned at the start, we will go ahead and rebroadcast this webinar today on all our Chamber of Commerce social media posting. So again, thank you very much. We'll see everybody next week. Goodbye.
Thank you.
Thank you, everybody. Thanks, John.
Thanks, Joshua.